Member for Nelson.
Thank you, Mr. President. Mr. President, I rise to speak on the Guardianship and Administration Amendment Bill, which we're considering here today, which is an incredibly important step forward in providing crucial rights-based protections to some of the most vulnerable people in our community. The people who sit at the heart of this bill, Tasmanians who require support for decision-making, are highly vulnerable, and we know that there has been a history where there have been instances of harm, disempowerment and suffering as a result of failures of our current guardianship and administration system. I do note the context which others have pointed to that have led us to today. It is an old act, a 30-year-old act. We have had instances of harm brought to light through the work of groups such as Advocacy Tasmania and other people who have lived experience in this area. There has been the independent review of the public trustee by Mr Bugg, which others have mentioned, which included some valuable recommendations, having found that the Act was being misapplied over an extended period of time. Also of note in terms of context is the work of the TLRI and also the Australian Law Reform Commission, providing also recommendations into this space for effective and contemporary reforms to be made. So all of that leads us here to today. And certainly when I make my contribution, I want to keep at the centre of consideration what this Act is about and the people to whom it applies at the centre. As described in Advocacy Tasmania's submission that was made on the draft bill, they said this: too many vulnerable Tasmanians have been imprisoned against their will, lost their treasured possessions, and often had to fight for months and years to regain some semblance of control over their lives. And Benjamin Jones, who has worked for Advocacy Tasmania previously, he provided me with some comments to better explain this. And this is what he put to me. It's really the direct experience of people being failed by this system that best demonstrates why it's so important to get this right. This is a community that has been fighting for decades for their basic rights, for choice, dignity and support, and to not have the views and decisions of others forced upon them for the convenience or comfort of others. This bill is a real opportunity to make it unequivocally clear what the minimum standards really are for guardians and administrators, and that current practices that too often completely override the rights and choices of people with impaired decisions need to end. I found that quite on point for really getting to the heart of what these reforms are all about. And Benjamin also provided some quotes from clients that Advocacy Tasmania has compiled in the course of their work, and that really illustrate the key issues of this situation. Some of those quotes include this: "No one spoke to me, just about me. All these huge decisions were being made about my life and I wasn't involved at all. It was so shocking how quickly I lost my independence." And another comment, Mr President: "I think everyone should get support through the process of an order if they want it. It's confusing and sometimes scary. When I told them that legal aid needs to be involved, I was told that they couldn't be there. I was really glad they were there. There was someone on my side. It should be everyone's right to have a support person or lawyer at the hearing. There should also be support for people to make important decisions in their life instead of sticking them on an order straight away. Give people a chance." Mr President, those sorts of direct voices from people affected, I think, are really important to put into this debate, and I'll have a few other instances of doing so in my contribution, because it makes it very clear that we've had something of a cycle of distress and harm that does need to end, as they have made the point so clearly. And this bill represents an excellent opportunity for a new beginning. In reforming the current Act, we have an opportunity to put in place a new approach that cements the strongest rights-based and contemporary practice for ensuring people with impaired decision-making ability are respected, treated with dignity, and empowered to be in control of their own lives to the greatest extent possible. Mr President, this reform simply is about justice. Our guardianship and administration systems are areas in which undeniably injustice has occurred and harm has been done. We should not now fall short in responding to that injustice. And Certainly, while I believe that the bill we are considering takes us forward in leaps and bounds with many carefully considered rights-based protections, I am also aware that there are areas in which it will still fall short. Listening to the criticisms of those with lived experience and community advocates who are central to this area of policy, I understand that there are a number of ways in which the bill has either not tackled key issues or has established an approach that is not preferred by those stakeholders. And this is disappointing. The very basis of the approach stated in this bill is that, to the greatest extent possible, the will and preference of the person at the centre should be given effect to. I do find it very unfortunate to note that in finalising the bill and bringing it to this place, it would appear that the will and preference of key stakeholders and advocates in this space on the level of protection needed in the bill was not necessarily supported to the full extent that it could and perhaps should have been. However, I do understand that there is a further tranche of reforms in this area, and the intention from government is that there will be further tranches to come, potentially. The first tranche of reforms from 2021 progressed some initial areas around making and implementation of advanced care directives. The second tranche applies similar principles across the rest of the Act. And I can only state here that I hope, as a matter of priority, the outstanding unaddressed issues that have been clearly identified during consultation and in reports such as that from the TLRI will be fully considered and given effect to in the next stage of reforms. Mr President, I note that the government congratulates itself on consultation conducted on this bill, and it was, in the end, a very good consultation. However, the original consultation period for the bill, I understand it, was only set at 3 weeks and did not include accessible and supportive documentation and submission processes. And given that the community members most affected by the legislation that sit at the heart of this bill, it was a significant oversight, I think, to initially go with that approach. I do understand that after strong requests and objections from groups such as Advocacy Tasmania and others, the consultation period was extended and expanded to provide better opportunity for people with lived experience to participate. And it's good that that response occurred and that opportunity was provided, but it's really a shame that there had to be efforts made to push for that rather than applying the same basic principles and respectful approach on which this legislation is supposed to be based, applying that from the outset to the processes around developing it and consulting on it with the community. Mr President, significant issues were raised in consultation, and some of which were responded to with changes in the subsequent final bill. I know, for example, that Equality Tasmania, who made a submission, were pleased with the inclusion of suggested changes made in their submission in relation to the meaning of promoting a person's personal and social well-being. As suggested by Equality Tasmania, that definition now explicitly includes having regard to a person's gender identity, gender expression and sexual orientation. That's a really positive change made in response to consultation. And also in the new section titled Decision-Making Ability and Impaired Decision-Making Ability, adjustments were made to the wording as suggested by Equality Tasmania to ensure all members of the LGBTIQA+ community are covered by protections that it provides. That's excellent to see that change incorporated. I do acknowledge, though, that Equality Tasmania wanted further changes, in particular to the definition of spouse. The definition of spouse, as it currently stands, includes registered and unregistered relationships pursuant to the Relationships Act without any further explanation or disclaimer. I know that Equality Tasmania's concern is that this could lead to TASCAT failing to correctly recognise a same-sex partner as a spouse, even if that person was in a significant relationship according to the Relationships Act. We've encountered this issue and discussed it in this place before, Mr President, and we would all understand where this concern stems from, the instance in which a coroner failed to correctly identify Ben Jago as a spouse, even though the Coroners Act similarly refers to the Relationships Act. To provide an important safeguard for the rights of vulnerable persons impacted by the Guardianship and Administration Order, Equality Tasmania did call for additional clarity added to the definition of spouse in this bill, wording such as irrespective of gender, and they point to Victorian legislation. And I mention this here now because I want to acknowledge the concern raised and the suggestion put forward by Equality Tasmania. My sense of of that issue is that it shouldn't be legally necessary to include such belt and braces definitions in individual acts, when a reference to the Relationship Act should be sufficient to ensure correct interpretation. It's something, I think, though, that we need to all keep a close watch on, especially in relation to... Yes, well, especially in relation to legislation that perhaps substantially impacts on spousal rights, to ensure that appropriate protections against discrimination are included. It also, I think, points to the need for a more purposeful and proactive training and education for anyone acting under legislation that requires the correct identification of spouse. There needs to be a focus on culture change to overcome conscious or unconscious bias within any government-delivered services or agencies in this area. So I acknowledge the concerns of Equality Tasmania, although I'm not presenting, for example, amendments to address the concerns that they raised today. I think it's worth having it on the record, because I do think it's something we need to be very mindful of, particularly if spouse is provided with certain rights or roles in a piece of legislation. Mr President, in consultation with various stakeholders, I have prepared some relatively minor amendments for consideration on the bill if we get to the committee stage. Those amendments don't address any large policy matters or new inclusions to the bill. The aim is to strengthen or clarify certain areas of the bill and to more clearly put at the forefront the rights-based foundation of the bill. They are in line with the work of the TLRI and the Australian Law Reform Commission, and when we get to those, I'll speak about them in more detail. Mr President, I note that supported decision-making is referenced in the bill in a number of clauses, but there is a concern raised by advocates around the lack of a legislated supported decision-making scheme or operational means to realise the appropriate supports for people with a disability in terms of decision-making. And a note from the Advocacy Tasmania submission on the draft bill on page 3, they said this: for comparison, in Victoria, half the legislated reforms and resulting act are based on operationalising and realising supported decision-making and giving them legal status and effect. And then further on page 4, they go on to say, so much of the operations of the Act depend upon the operation of informal and formal decision supports and the state ensuring access to them. Without it, the bill is really missing its heart, or the mechanism by which change and rights are actually realisable for people. So, Mr President, that does leave a question over whether, with no legislated supported decision-making scheme, there risks being not a shift in practice, but only potentially a shift in language and optics presented through this bill. I recognise that concern, and I understand that the government may wish to reflect on why that hasn't been included here and what future intention there might be to see some operational means that sits alongside this bill to ensure that supported decision-making does actually come into effect and practice in a way that is indicated by the bill. Mr President, clearly of central importance here is the interpretation or assessment of a person's decision-making ability. The definitions, the requirements for what must be considered, and the application of principles must all be clear and effective in this legislation. Remembering also that a person, decision-making is a complex, or decision-making ability is a complex area. It's an ability that can come and go. A person can potentially even have decision-making ability in some aspects, but not others at any given time. Practicable and appropriate supports, as referenced in various places in the bill, can make all the difference in a person having decision-making ability. And the degree to which such supports are provided and reasonable steps to provide them need to be exhausted. And it's a really crucial aspect to ensure that that is not just a nice idea if it's convenient to apply, but actually central to what is required when ensuring that people are correctly assessed in terms of their decision-making ability. Mr President, as I seek to do at every opportunity, I would like to make some comments in relation to human rights. And as you may well expect, I will state my strong support for and call on the government to progress the establishment of a Human Rights Act for our state. As is appropriate and contemporary, rights-based approaches are being introduced into many pieces of legislation and legislative reforms here in Tasmania that we then come to consider in this place. And this bill is another example of that, and I'm pleased to see it. In the absence of an overarching Human Rights Act for Tasmania, our best way forward is to develop policy, to govern and to legislate as if we do have one in place. So explicit inclusion of rights-based approaches in legislation is one key way for us to do that and to be moving our way towards what I think is inevitable, and that's that we do have a Human Rights Act for our state. But this bill, Mr President, introduces objects of the Act in Section 7 which reference the need to apply the principles of the Convention on the Rights of Persons with Disabilities, including recognising the need to support persons with impaired decision-making ability to participate in and implement decisions that affect their lives. This is an excellent inclusion to establish an important foundation of rights-based principles. That foundation of principles has to then be actively reflected throughout the legislation and accountably implemented when the legislation is being applied. And that is where we know things have fallen down under the current legislation, with the Bug Review finding that those implementing the legislation relating to the public trustees have been misinterpreting that in significant ways over an extended period of time. So what's in legislation, particularly in the high-level end of that legislation in the objects or the principles, must be accountably then implemented through the legislation and when it is given effect in practice. Without effective mechanisms to hold those exercising powers under this legislation to account for acting in accordance with the rights-based principles that underpin it, the vulnerable people at the centre of this are still at risk of having their rights violated. I do also note the very important inclusion in the bill of principles to be observed in Section 8. The principles outline fundamental rights-based principles that a person performing a function under this Act is to observe. And the principles include a person's decision-making ability to be respected and promoted. A person who requires support in decision-making is to be provided with access to support necessary to enable the person, as far as practicable in circumstances, to make and participate in decisions affecting them, and to express that person's will and preferences, and to develop the person's decision-making ability. The principles also recognise that the views, wishes and preferences of the person are to be respected and used to inform decisions. They recognise the role of close family members, carers and other significant people in the life of the person with impaired decision-making. They recognise the importance of preserving the person's cultural and linguistic environment to promote the personal and social well-being of the person, and to adopt the means which is the least restrictive of the person's freedom of decisions and action as possible. Further, the principles in relation to decision-making are further elucidated in relation to children in the Act. So that's a really strong section of the Act and pleasing to see. Again, we understand these principles are then to underpin the other aspects and the details in the Act. But what's really important is that we are very clear and strong in understanding how that will be accountably implemented and how we can ensure that those mechanisms adhere to the mechanisms in the Act adhere to the principles underpinning. Mr President, while it's very positive to have the fundamental principles laid out, we do need to ensure that all other aspects of the bill reinforce them explicitly throughout, and some of my amendments relate to that. Further, it's important that there are effective mechanisms to hold accountable people who exercise powers and functions under the bill, and that there be some way to challenge instances in which the principles are not believed to have been applied correctly or to the extent that they should. And I'll speak more on that a bit later. Mr President, I want to note the part of the bill that deals with emergency orders. Emergency orders under the current system have been an aspect that has caused considerable harm and suffering, with life-altering permanent decisions being made through the imposition of emergency orders. So many of the issues that have been raised in the recent years in the media have been caused by way of emergency orders that have been used and managed in ways that have caused harm. There are orders These are orders that allow someone else to make crucial decisions about a person's life without their consent for up to 2 months. I know Advocacy Tasmania has described witnessing emergency orders being used under the current legislation to do things such as permanently put people into residential aged care, to sell people's treasured possessions, to decide that that person will give up their public housing tenancy, and to make other irrevocable choices in a person's life. Under the current system, these orders have been made, I think, far too readily without appropriate accountability, and have been far too broad in their impact and effect. I do note, as others have noted, I know the member for Launceston spoke about this very well, there have been many efforts in recent times made within the public trustee under the leadership of the now CEO, Todd Kennedy, to change approaches and change practices in that context. But these concerns around emergency orders are particularly pointed because of the rapidity with which they're brought in to address urgent situations, and then the potential permanent impact that they can have. I do note that some advocates argue there's no need for emergency orders under this Act because they point to provisions under the Mental Health Act or under common law to deal with urgent emergency situations, especially situations of serious risk to life and health. So I would be interested to have on the record some reflections from the government on why it doesn't regard aspects provided for under the Mental Health Act and under common law to be sufficient to deal with most situations that we would think would be related here under an emergency orders provision. Mr. President, under this bill, we do have emergency orders still available to be made by the tribunal if it's considered a represented person or an unrepresented person is in immediate risk of harm. There is an improvement, certainly an improvement on current requirements in this bill. The tribunal may make emergency orders only on application and after a hearing, and that process is really been made more rigorous compared to what has been the practice, is my understanding. My understanding is that the bar should now be higher and the accountability around the decisions to impose an order should be greater. However, under this bill, the emergency orders can still be put in place for 28 days and then renewed for a further 28 days, adding up to a period of close to 2 months. And that is, for many, regarded as an unacceptably long time for orders of this type. Certainly that's been expressed by many lived experience advocates, and there's a concern there. Having discussed it during briefings, I do also hear the point made that to shorten that time frame significantly is potentially problematic because it doesn't necessarily allow time to schedule and then undertake a full hearing of the tribunal to fully consider the circumstances of that person's life and to consider a regular order that may need to be made. Accepting that, I think it's even more important if that time frame is to remain 28 days plus 28 days in which emergency orders can be imposed. It's even more important that we have very good clarity around what may be decided on and to what extent under those orders, and the scope of that. The impact that it can have on a person's life and the permanency of that impact are even more important to get right. Mr. President, I know that another concern from advocates is that the standard for what qualifies as an emergency is set too low in their assessment. Immediate risk of harm is defined in the bill as being an immediate risk of harm to the health, welfare, property or financial situation of the person, including because of the risk of abuse, exploitation or neglect of the person or self-neglect. The contention and difficulty do then or can arise when the need to allow the dignity of risk comes into play and when there may be impacts on the convenience of others, or when it can be too easy to have personal views and judgments of decisions being made by a person which others deem to be inappropriate. So I think there's a real tension here in anybody deciding on behalf of another person that they're making bad decisions, essentially, or making decisions that put them in immediate risk of harm. And that's a very tricky test, I think. Certainly the shift we have, the fundamental shift in model from what we've had, which was the best interests approach in this area, to the general shift to a will and preference approach is really crucial here if it then is rigorously applied into this emergency order space as well. Under the current approach, where decision makers can step in and make judgments on what's in the best interests of a person with impaired decision-making ability, those grey areas around what constitutes immediate harm and warrants the need for an emergency order, I think has contributed to being very problematic and harmful, because it does allow then for factors such as judgments and convenience and disagreements on degree of risk to come into play. Under the will and preference model in this bill, there should be a cultural shift broadly, including in this area, in the level of regard and respect that's afforded to the person at the centre, including respect for their right to engage in the dignity of risk in decisions relating to their life and their circumstances. Mr. President, I do want to bring forward here into the debate some voices of lived experience so that we can understand the importance of how we improve this area of emergency orders and more fully to illustrate the issues that have been there that need to be addressed as we look at bringing forward these reforms. I looked at the Advocacy Tasmania submission, which was made in December last year, a submission to the Royal Commission into violence, abuse, neglect and exploitation of people with disability on guardianship and administration. And from page 10 of that submission, this is some material I want to put onto the record. So many of our clients have had horrific experiences with emergency orders under the GA Act. These orders can be made when someone feels there is an immediate risk of harm to health, welfare or property and last for up to 2 months of a person's life. Emergency orders can apply in a plenary fashion in that they can cover decisions on all matters and can lead to permanent disempowerment for people subject to them. We see incredibly disturbing trends in the use of emergency orders, including how they are requested, what evidence is required for an order to be made, what powers are granted under orders, and the accountability of guardians and administrators, including the public guardian and public trustee, in ensuring the will and preferences of persons under orders are fully considered and respected. In our experience, the requirements in the GA Act that a guardian/administrator must consult with the person under orders and take into account their wishes are routinely ignored in practice. The obligation for administrators to support the person under orders to develop their decision-making capacity is functionally not being implemented by the public trustee in Tasmania. Instead, our clients are lucky if they receive a single contact from the public trustee annually. We have worked with clients who have had life-altering decisions made on an emergency basis under the GA Act, such as being placed in permanent residential aged care, having access to community and housing supports terminated and having all their treasured possessions taken to the tip. These decisions can be impossible to undo and should never be made on an emergency and permanent basis, but regularly are. Before 2022, we observed that many emergency orders were made on the papers without an actual hearing, notice or opportunity to speak. Thankfully, this practice has now ceased following our considerable systemic advocacy. However, it demonstrated a fundamental problem with the guardianship and administration system, that decisions can be made in a plenary fashion for people based on very low thresholds and evidence without the person being present or aware that decisions are even being made about them or what their impact might be. The system allows and supports these huge denials of shared humanity and due process as almost a matter of course. It's appalling there are so few protections, checks and balances built in to prevent this from occurring. So that was a quote from the Advocacy Tasmania submission to the Royal Commission, Mr. President. And I think it's important because to highlight the ways that the current system has been failing is important for us to have front of mind when we're considering and contemplating how well this bill moves us forward and addresses those issues, and whether it does so with enough rigour and strength to not have us arrive in a situation where we might see such problems arise again. And I appreciated that Advocacy Tasmania submission, which had some direct quotes from clients about emergency orders. And I want to mention those here too, just to put it on the record. Because when we are talking about this, if we move through to the committee stage and we have questions or we have amendments to consider in relation to emergency orders, it's important to be clear about, as I said, those issues or problems that we're trying to address with this legislation. So one of Advocacy Tasmania's clients, quoted in their submission to the Royal Commission, said this: "I went to hospital after a fall and eventually I was put on an emergency order. No one discussed this with me or invited me to attend a hearing. In fact, the order was done while I was unwell and on loads of medication. At the hearing, it was decided that public trustee would also be appointed. Public trustee went on to sell or throw away all my belongings, having never discussed any of it with me. Most of my photos and personal items were just gone for good. I even had a few $100s in a large jar and that money was gone too. They changed the locks on my home. People should be involved in any decisions about their own life, where I was not. The guardian and the public trustee just came in and took over." Advocacy Tasmania in that submission goes on to say, "Imagine having your whole life overturned based on an alleged urgency you disagree with, being removed from your home, having all your possessions disposed of, and being forced into residential aged care against your will. You're telling everyone what you actually want, and they're ignoring you and aren't interested. You have no ability to actually challenge what is being inflicted on you, and the choice is being made for you. It's horrific, and it happens again and again. It's an insidious violence being perpetrated against the most vulnerable, and it happens at a time when they should be receiving the most support, options and choice instead." I think that this is really important, Mr President, that we have this in front of mind when we're thinking about how well we're solving these issues that have been demonstrated in the past and what we can do, not only to technically on paper address them, but to also provide support and confidence out there to the community, to the vulnerable people who will be impacted by this legislation, support and confidence that these situations will not occur again, or at least that the most is being done in the legislation and in giving it effect to ensure that that doesn't happen again. There's some other stories presented by Advocacy Tasmania. I'm going to share one more on the record because I think these people deserve to have their words on the record here in front of mind when we're considering these reforms. It's a de-identified client story presented in Advocacy Tasmania's submission to the Royal Commission, and it's titled Jennifer. It's page 12 of that submission, and I'll quote: "Jennifer has moderate mobility impairments associated with her condition, but no identified impairments in her mental or decision-making ability. She sought advocacy support when, after a stay in hospital to recover from an injury resulting from a fall, she had been denied the right to discharge herself from the hospital to return home. The advocate sought urgent legal support for Jennifer, which determined that Jennifer was under no legal orders at that time and that she had the right to be discharged. When Jennifer attempted to leave the hospital, accompanied by her advocate and under legal advice, hospital security was called and Jennifer was threatened with a code black, physical and chemical restraint. Jennifer was unwilling to risk being physically and chemically restrained and elected to wait, at which point the hospital applied for an emergency guardianship order. Despite no previously identified impairments in Jennifer's decision-making capacity, the 28-day order was granted and Jennifer was restricted from leaving hospital. Jennifer wanted to appeal the emergency order, but there was no appeal or review pathways available to her within the 28-day period of the order, such as to TASCAT or the Supreme Court." That's the end of the quote. Mr President, I believe it's important to share these so that we have a clearer understanding of the need for reform and a better understanding of how to assess the reforms presented to us in this bill. I think it's important for us to understand that given the egregious disregard that we have heard about in terms of people's rights and dignity experienced under the exercise of these emergency powers over decades, we must be supremely vigilant in ensuring that any new model presented in this bill provides the highest of protections. And I would invite the government to reflect on and perhaps emphasise the points at which the new reforms presented here around emergency orders provide that protection that's described as lacking in what we've previously had and what these people, such as Jennifer, de-identified Jennifer, have experienced. We know, Mr. President, and we've heard from many advocates about the fact that emergency powers under the bill can be and have been exercised harmfully. Not every time, certainly not every time, but far, far too many times. And knowing this, we must do nothing less than guard against such abuses of power as vigorously as we possibly can. So I remain concerned that the bill falls short in this area. I have sympathy for the call from lived experience advocates for the powers in relation to emergency orders under this bill to be more appropriately constrained than is currently drafted, and that's something we will discuss in amendments if we reach the committee stage. Mr. President, it's pleasing to see the bill address the matter of gag provisions under the current Act. Currently, we have the unacceptable, damaging situation where people are prevented from talking about their own story. This has had harmful consequences for those, in some cases, who have not only had their autonomy, their dignity and their rights taken from them, but have then been legally silenced to speak about it. And further, the negative impact of those gag provisions has not only been individual, but it's also been systemic. The confidentiality provisions in the current Act have likely played a role in delaying much needed reform in this area because people weren't allowed to speak about it. Effectively silencing individuals also effectively silences systemic advocacy in many circumstances. So how much suffering might we have avoided if through more timely reforms if people hadn't been silenced in that way? So the bill quite rightly amends these confidentiality provisions to allow people under guardianship orders to consent to the publication of their information if they wish. And it's a really positive development. Mr. President, one area of concern for me around the bill, though, is the lack of potentially effective provisions to ensure compliance with the Act once it's in practice. The Advocacy Tasmania submission does point to many stories from clients who've been experiencing great harms and that they were put through processes that didn't necessarily comply with the current Act even, limited though it has been. And then there's been a deficiency in avenues by which to see that redressed. I do know that there's a key concern from advocates potentially that the process that's being put in place in this bill, which is a positive step forward to put a complaints process in place and a mediation process in place to resolve disputes, but this bill does locate that within the sphere of the public guardian. And people have pointed to the fact that the public guardian is often directly involved in decisions made by the public trustee or as the guardian itself. So there's a potential difficulty there that's not seen as an unconflicted avenue of resolving disputes. I do note, and certainly this has occurred since the TLRI report, so it wasn't contemplated in the TLRI report, but subsequent to that we have established in this State Disability Commissioner, and I know that some people in submissions put forward suggestions that it would be more appropriate to facilitate a dispute resolution process or mechanism as a function of the Disability Commissioner, as an entirely independent and appropriately credible entity to resolve those disputes. I'm not putting forward a suggestion as to what is the right way forward. I'm raising the concerns that have been put up. It's certainly very positive that we do have a more explicit way for disputes to be brought forward and addressed, but perhaps that's something that will need to be improved or developed further over time. Timely resolution, certainly, of complaints is another issue. I don't see minimum timeframes or expectations or specified timelines around the resolution of complaints or issues that are brought forward. I wonder about what the escalation pathways might be and the timeframes on that too. It's certainly something that would be necessary, I think, for the vulnerable people out there and their family, friends, carers, supporters who might need to utilise dispute resolution or complaints mechanisms, it is important to have security and confidence in the mechanisms available, and to understand clearly what the timelines will be, what the process will be. I'm not sure if there's a reason, for example, that timelines and timely resolution of those that complaints process wasn't included in the bill, but if the government's able to provide a comment on that, I'd be interested to hear it. And as we have had pointed out and referenced, I think, in the government's second reading speech, the bill doesn't contemplate penalties, compensation for offences in relation to people's misusing or not abiding by the legislation. Community advocates point to the fact that the bill appears to be missing teeth when it comes to penalties and compensation for non-compliance. They point to the fact that there are currently no penalties, compensation or consequences for people and organisations that fail their responsibilities under the bill. And I do understand from the second reading speech that the department has been tasked to consider this issue further in future tranches for reform. And that's pleasing. I think if that's the intention, that's positive, and we'll look forward to it. However, having no meaningful recourse for penalising those who fail their responsibilities under this bill, should it pass, or for providing compensation to those who may be harmed by such failures, I think is a major obstacle to achieving justice that we would want to see in this area delivered by this bill. There will be a lag time between this bill potentially coming into effect and then a future tranche which may contemplate issues around penalties and offences and compensation. And during that lag time, of course, people who come into the sphere of this bill won't have those things available to them as part of the protections that are there and the recourse that's there. I note the part of the bill that deals with health and medical research. It's being inserted into the Principal Act to establish a framework for authorisation of medical research on people with impaired decision-making ability. Mr. President, the intention to provide a framework and safeguards to regulate the involvement of people with impaired decision-making in health and medical research is understandable, and I hear the arguments put forward for situations in which what's provided for in the bill may assist in good outcomes. However, concerns have been raised that the bill takes an approach which is incompatible with the hard-fought rights of people with disability and older people. I know that looking to the Advocacy Tasmania submission on the draft bill, that organisation regards this section as, and I quote, fundamentally misguided and likely to substantially detract from improvements in the legislation. I do also note Article 15 of the Convention on the Rights of People with Disability provides protection for people with disability from being subject to medical and scientific experimentation without their free consent. The provisions in the bill appear to be contrary potentially to that international human rights law, which views medical research without consent on people with a disability as tantamount to torture or cruel, inhumane and degrading conduct. I note that in the TLRI submission to consultations on the bill, they said not to progress these sections without further research and consultation, as they had not touched on it in detail. I quote from the TLRI, "It is recommended that the implementation of these reforms be delayed and dealt with separately after greater consultation. The TLRI report did not deal in depth with issues around medical research, though medical research was flagged in recommendations 13.10 and 13.11. It goes without saying that strong safeguards must apply to medical research. It is recommended that the bill progress without the medical research provisions until further research and community consultation has been conducted." End of quote. And I note that groups such as Advocacy Tasmania strongly agree with that sentiment from the TLRI and that recommendation that this be an area for further consultation and research. I don't really understand why some things have been delayed for further consideration and consultation in the next tranche, but something that has been as clearly identified as needing further consultation and research, such as this aspect of consent to health and medical research, by people with impaired decision-making has not been and has been put forward in this tranche. I hear the argument made from lived experience advocates that rather than removing rights protections in the way that this does for people with impaired decision-making ability, the approach fundamentally should be and needs to be one of removing barriers for people with impaired decision-making ability to be involved in medical research, and alongside that providing real support for people to decide for themselves. So rather than be quick to allow others to override what might be the situation for a person with impaired decision-making ability and potentially consent on their behalf for them to be involved in health and medical research, there should be more focus on how to better support people with impaired decision-making to be in a position to make that decision themselves. The case is made that if there are broader changes needed to give effect to this, those changes should apply to the community as a whole in a separate consent to medical treatment and research piece of legislation, not in this bill where they'll be applied in a discriminatory fashion, it could be argued, to a particular group of people whose rights are being traded away. Mr President, while the government asserts that this aspect of the bill strikes the right balance, I'm not convinced that it's nuanced enough in balancing rights protections here. The second reading speech from the government aims to make the argument with a very specific example here, which is all well and good, but if the provisions proposed are too broad so as to allow lesser incursions on a person's autonomy and liberty, we are right to still be concerned about it, I think. One good example doesn't constitute a convincing rationale when we're talking about trading away people's rights. I do wonder why hasn't the government sought to give full expression to the protections demanded by Article 15 of the Convention on the Rights of People with a Disability? I do also feel that the way this has been inserted into the Act feels like it harks back to what we are stepping away from, which is that best interests approach, where someone decides whether it's in a person's best interest to be involved in health and medical research and can consent on their behalf to it. I note that the government...
Through you, Mr President, I wonder whether the honourable member might like to give an example of what you're thinking of, I mean, as opposed to... Mr President,
I'm delivering my second reading speech. I'd rather not engage in an interactive debate. Okay. So, if there's something that the leader wishes to follow up with me about afterwards to include in a summary, I'm happy to have that conversation during the next break. I note the government does emphasise that not all areas are addressed in this bill and that there will be those further tranches of reform. And I do wonder why this matter wasn't dealt with in a further tranche after greater consultation and consideration as recommended by the TLRI. So, Mr President, I note again and I'll quote again from the Advocacy Tasmania's submission to the Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability on Guardianship and Administration, which they made in December last year. Page 19, they said this: "We must urgently move beyond treating people as less because of their status or function and focus instead on their human rights, agency, support needs and giving effect to their will and preferences. The reality is people make decisions in a wide variety of ways. These ways are often personal, emotional and strongly driven by values and experiences. But for those with disabilities or who are older, we routinely see them deny the dignity to make decisions in this diversity of ways, especially where there is an element of risk. We need to move past trading the respective rights of people with disability away. The right to safety and to live free from abuse, neglect and violence is not more important than the right to agency, liberty and legal capacity. We need to support all these rights concurrently and in ways the current substituted decision-making approach fails to do." So, Mr President, I profoundly hope that with this bill we're taking giant steps down that path to upholding and supporting those rights, that totality of rights for all Tasmanians. I know that even with the progress that is in this bill, undoubtedly there will be more work to be done. I know that the government is intending to continue these reforms, and I strongly urge the government to continue that work in a timely way and with input and direction of those Tasmanians with lived experience and their advocates at the very centre of progressing that work.